Hi, I'm Max Dilendorf, an attorney based in New York. My firm represents businesses nationwide in match list removals and preemptive asset protection strategies. If your payment processor suspended your merchant account and placed you on the match list, also known as the terminated merchant file or TMF, this video is for you. I will explain what the match list is, what to do immediately to protect your rights, and how match list removal works. I recently spoke with a business owner who operates 5 gas stations. His processor blocked him, alleging that he was selling illegal products, and placed his name on the match list. Overnight, none of the 5 locations could process a single card payment. 5 businesses frozen over one allegation. Match stands for Member Alert to control high-risk merchants. A database, MasterCard, maintains that effectively every major processor checks before approving a new merchant. And once your name, your principal's names appear on the list, you're not just suspended by one processor. You're frozen out of the entire payment system for up to 5 years. So for any business that runs on card payments, that's not an inconvenience. That's the lights going out. Consider a costly mistake I see repeatedly. A merchant was litigating a match listing in federal court for years. Substantial damages claim, experienced counsel, and lost the case entirely because they never closely read their own contract. The short merchant agreement you sign incorporates a much longer program guide. Fine print that lets the processor terminate you, hold your funds in reserve, and report you to match, and disclaim any liability for that report. So when the merchant argued the processor had no right to act, the court pointed out to the program guide and said you agreed they could do it to you. So even claims that sound compelling, like breach of fiduciary duty, negligence, fail because a processor isn't your fiduciary, and the economic loss doctrine could bar negligence claims in some states. On top of that, these disputes almost always proceed through mandatory and binding arbitration, because that's what contract you signed requires. Arbitration is a lengthy process, and many of these agreements require 45 to 60-day notice before you can even file the case. So the clock keeps running while your business still can't accept any payments. So how's the business actually removed from the match list? Well, not by arguing the treatment was unfair. That's not a legal theory, and the contract is built to defeat it. The case turns on the reason code. You should demand that the processor state in writing the precise reason for the listing, then measure that reason against the facts. And here's the pivotal point. The processor is protected only if it had a legitimate basis to terminate you. So the entire matter reduces to one question. Was the stated reason accurate? Return to the gas station. They were listed for illegal activity. If we establish that the products were legal and the transactions legitimate, the stated reason was false, and the false reason means no valid grounds. The processor's protections fall away, and the listing itself becomes the error we challenge. That's the case that prevails. Removal from the match list is achievable, but only where the facts support it. If the processor's stated reason is accurate, removal becomes very difficult, and we'll say that upfront to the client. So the first step is realistic assessment of whether you have a viable claim. We represent businesses nationwide against banks, card networks, and payment processors, and we understand how these institutions draft their contract and how they defend them. So there are 2 ways that we can assist. The first is first response. The moment you have been placed on match list, the clock begins, and the early days are decisive. Our team acts immediately, nationwide, to do what must be done at once. Secure the contract, compel the reason code in writing, preserve the evidence that your business was legitimate, and protect every right before a deadline forecloses it. Acting quickly and correctly is what positions you before removal. The second is prevention, and this is where asset protection applies. If you operate in a category processors treat as high risk, you structure before a problem arises. a separate entity for the high-risk product line, with its own banking and clean separation. So if you operate in a category processors treat as high risk, use structure before a problem arises. A separate entity for the high-risk product line, with its own banking and clean separation. So one flagged line can bring down the entire operation. At those 5 gas stations been structured that way, a single termination would not have frozen all 5. That's business continuity, precisely the risk we structure against for operating businesses and family offices we advise nationwide. If your merchant account has been terminated and you've been placed on match list anywhere in the country, time matters. Secure the contract, obtain the reason code, and consult the firm that handles match list removals. Contact my office through the link below, and we'll assess whether removal is realistic in your case. I'm Max Dilendorf, and I will see you in the next episode. Thank you very much for watching.